The President told the SCA that he, and I quote, had every intention in the future to continue to use such processes as are available to him to resist prosecution, I close quotes. In other words, not to stand trial at all, and this would place the incumbent NDPP firmly on the spot. It seems incongruous that under those circumstances, President Zuma should then be seen to be appointing the NDPP, since his conflict, both actual and perceived, is self-evident. Judges decline routinely to sit in matters in which they are conflicted. I turn now to the constitutional challenge by CASAC. It is necessary to refer to the two provisions that are being challenged. And I quote, Section 12, term of office of National Director and Deputy National Directors. Subsection 1. The National Director shall hold office for a non-renewable period of 10 years, but must vacate his or her office on attaining the age of 65. Subsection 4. If the President is of the opinion that it is in the public interest to retain a National Director or a Deputy National Director in his or her office beyond the age of 65 years, and A, the National Director or Deputy National Director wishes to continue to serve in such period, and B, the mental and physical health of the person concerned enable him or her to so continue, the President may from time to time direct that he or she be so retained, but not for a period which exceeds, or periods which in the aggregate exceed 2 years, provided that the National Director's term of office shall not exceed 10 years. Subsection 6A, the President may provisionally suspend the National Director or a Deputy National Director from his or her office, pending such inquiry into his or her office, or her fitness to hold such office as the President deems fit, and subject to the provisions of this subsection, may thereupon remove him or her from office for misconduct on account of continued ill health, on account of incapacity to carry out his or her duties of office efficiently, or on account thereof that he or she is no longer a fit and proper person to hold the office concerned. The removal of the National Director or Deputy National Director The removal of the National Director or a Deputy National Director, the reason thereof, and the representations of the National Director or Deputy National Director, if any, shall be communicated by message to Parliament within 14 days after such removal, if Parliament is then in session, or if Parliament is not then in session, within 14 days after the commencement of its next ensuing session. Parliament shall within 30 days after the message referred to in paragraph B has been tabled in Parliament, or as soon thereafter as is reasonably possible, pass a resolution as to whether or not the restoration to his or her office of the National Director or Deputy National Director so removed is recommended. The President shall restore the National Director or Deputy National Director to his or her office if Parliament so resolves. The National Director or Deputy National Director provisionally suspended from office shall receive, for the duration of such suspension, no salary or such salary as may be determined by the President. I close quotes. The applicant submitted that Section 12(4) was inconsistent with the Constitution, relying by parity of reasoning on the Justice Alliance case. There, the Constitutional Court held that Section 8A of the Judges' Remuneration and Conditions of Employment Act, which allowed the President to request a Chief Justice who is about to be discharged from active service to continue in office as the Chief Justice for an additional period determined by the President, if the Chief Justice acceded to that request, as unconstitutional. Thus, the Constitutional Court held that powers of extension of tenure were inimical to judicial independence, which implies in turn freedom from external interference. The applicant relied too on the Helen Suzman Foundation case versus the President of the Republic of South Africa and the Glenister case, which were concerned with the adequacy of structural and operational independence of the Hawks in the South African Police Service. The same principle, that of jealously guarding against external muscling by the executive, was applied. This is, of course, powerful, but also binding authority if it applied with equal constitutional justification to the position of the NDPP. The applicant submitted that it did, given amongst others, the impartiality exacted of the NDPP in terms of Section 32(1) of the NPA Act. The respondents did not challenge the conceptual founding of the applicant's argument. Rather, they argued that the declaration of constitutional invalidity sought was academic and thus untoward on the authority of the Shuttleworth case. It seems to us that the Shuttleworth case was a very different case altogether for the following reasons. First, there is the ambitious reach of the Shuttleworth case. Not only were a number of provisions of the exchange control regulations targeted, but the boundaries of the fallout of an order of unconstitutionality were not evident. Here, 2 subsections only are targeted, and its effect in both cases is clear. Second, Shuttleworth's locus standi to act in the public interest had not been shown. Here, it is not disputed. Third, Shuttleworth's contentions were disputed. Here, they are not. And fourth, there are, in this case, wholly absent in Shuttleworth, constitutional court authority that, if not directly, certainly is close to being in point. In the result, the challenge to the presidential power under Section 12(4) to extend the tenure of the NDPP is upheld, and we make an appropriate order below. That leaves Section 12(6) and its allegedly objectionable features of a unilateral presidential power to suspend for an indefinite period and without pay. Here, as stated, the applicant relied on the Helen Suzman Foundation case. It relied too on the case of McBride versus Minister of Police. Thus, the power to suspend without pay defies the exceedingly important presumption of innocence until proven guilty, or the audi alteram partem rule. In this matter, the President did not attack the principle underlying the argument, but argued that the declaration would be academic. But for reasons already given, we do not agree. The minister argued that the fact of a potential review of the irrational exercise of a presidential power was a complete answer to the constitutionality attack, but, submitted the applicant, this proposition has been rejected by the Constitutional Court in the Glenister case, and we agree. Costs and the order we are granting. Since the applicants are successful, it is unnecessary to engage on the applicability of the BioWatch principle. In the result, we make the following order on the application of Corruption Watch and Freedom under law. 1. The settlement agreement between the President, the Minister of Justice, and Mr. Ngasana, dated 14 May 2015, is reviewed, declared invalid, and set aside. 2. The termination of the appointment of Mr. Ngasana as National Director of Public Prosecutions is declared unconstitutional and invalid. 3. The decision to authorize payment to Mr. Ngasana of an amount of 17,357,233 rands in terms of the settlement is reviewed, declared invalid, and set aside. 4. The appointment of Advocate Abrams as National Director of Public Prosecutions is reviewed, declared invalid, and set aside. 5. Decisions taken and acts performed by Advocate Abrams in his capacity as the National Director of Public Prosecutions are not invalid merely because of the invalidity of his appointment. 6. Mr. Ngasana is ordered forthwith to repay to the state all the money he received in terms of the settlement. 7. it is declared that in terms of Section 96(2)(b) of the Constitution, the incumbent president may not appoint, suspend, or remove the National Director of Public Prosecutions or someone in an acting capacity as such. 8, it is declared that as long as the incumbent president is in office, the deputy president is responsible for decisions relating to the appointment, suspension, or removal of the National Director of Public Prosecutions, or, in terms of Section 11(2)(b) of the National Prosecution Authority Act, someone in an acting capacity as such. 9. The orders of invalidity in paragraphs 2 and 4 above are suspended for a period of 60 days or until such time as the Deputy President has appointed a National Director of Public Prosecutions in terms of paragraph 8 above, whichever is the shorter period. The cost of this application must be paid jointly and severally by the President, the Minister of Justice, Advocate Abrams, and the National Prosecuting Authority. In the result, we make the following order on the application of the Council for the Advancement of the South African Constitution. 1. It is declared that Section 12(4) of the National Prosecuting Authority Act 32 of 1998 is unconstitutional and invalid. 2. It is declared that Section 12(6) of the National Prosecuting Authority Act is unconstitutional and invalid to the extent that it permits the President to suspend the National Director of Public Prosecutions unilaterally, indefinitely, and without pay. 3. The order of invalidity in paragraph 2 is suspended for 18 months. During the period of suspension, 1. An additional subsection shall be inserted after Section 12(6)(a) that reads, the period from the time the President suspends the National Director or a National Director to the time he or she decides whether or not to remove the National Director or Deputy National Director shall not exceed 6 months. And Section 12(6)(e) shall read, the National Director or Deputy National Director provisionally suspended from office shall receive for the duration of such suspension his or her full salary. 5. Should the President fail to enact legislation, should Parliament fail to enact legislation remedying the defect identified in paragraph 2, the interim order in paragraph 4 shall become final. The President, the Minister of Justice, and the National Prosecuting Authority shall pay the applicant's costs, including the cost of 2 counsel. The orders of invalidity made above relating to the National Prosecuting Authority Act are referred to the Constitutional Court in terms of Section 1655 of the Constitution for confirmation.
I agree. I agree.
And so it is ordered, and I hand down the judgment.